Good evening, everyone. My name is Marshall Arnwine. I serve in the role of police practices for the ACLU of Northern California, and I'm here co-presenting with my colleague, Sean. And before we begin, we just want to be mindful that AB 392 is a step forward to reimagining public safety and police accountability. We at the ACLU is mindful of the country's current climate of addressing policing in America, and we view AB 392 as an essential step, but not the whole story when it comes to addressing police use of deadly force. And the ACLU wants a process that protects people from harm and does not contribute to it. In the world we have now, officers can inflict deadly force and abuse their power without accountability. We understand that AB 392 will not eliminate every police issue or killing, but AB 392 will help hold law enforcement accountable. Accountability is necessary on the path toward reimagining public safety and policing. AB 392 has transformed California to having one of the strongest use of force standards in the country. And we need police departments to adhere to the AB 392 law because the policies are connected to how police departments are trained and ultimately held accountable. And now I'm going to turn it over to Sean, who is going to discuss a brief overview of AB 392 and how we got here. And Sean will do his best to keep it brief because DOJ has done a great job thus far of explaining AB 392, and the commissioners have great questions that have answered a lot of the things that we were planning on presenting. But because this topic is so important, we'll make sure to cover this in a concise manner.
Great, thanks Marshall, and thanks to the Commission for inviting us to present. I do think some of what we're gonna cover here complements the presentation already provided by Cal DOJ. Some of what we're presenting has effectively already been covered, based on what we just heard. So we are gonna probably breeze through some of this stuff, and then, of course, if there are questions at the end, we'll try to address them. I want to start by recognizing that we've already had the opportunity now to engage as an organization that advocates for significant use of force reform for more than 2 years. Back in April of 2018, shortly after the tragic killing of Stephon Clark, our colleague Adriana Wong presented to this very body, going over some of the major deficits of the existing use of force policy then. And even as the use of force policy began to be amended, we continued to engage and urge significant reforms, including through a fairly elaborate letter that was sent to the City Council in March of 2019, and which echoed a lot of the recommendations that the Commission was making at the time, and some of which have, of course, now become state law in the form of AB 392. We have continuously thought that Sacramento should be a leader in use of force reform and in creating a better vision for the limits and best practices that police should exhibit. And we continue to think that that's incredibly important, in part because Sacramento is the seat of state government, and also because there have been so many tragic killings in recent years that have occurred in and around Sacramento. So with that background, I wanted to, it seems like there's already quite a bit of common knowledge among the Commission in terms of what AB 392 fundamentally does. So I will move pretty quickly through the next slides, but we did want to cover the foundational information that will then inform what Marshall will say about specific requirements that are not being met. So as I think everybody's aware, AB 392 has a fundamental legislative intent of ensuring that police officers are only using deadly force when it's absolutely necessary. for certain specified purposes. And, of course, the law recognizes that each incident is going to be conditioned on the particular circumstances in which the force might arise. But necessity remains the guiding objective principle under the law. Next slide, please. So again, this is just making sure that we all have a common foundation here, but there are a number of, as Commissioner Guerrero put it earlier, very carefully drawn requirements in the law. So what AB 392 did fundamentally was, of course, amend this provision of the California Penal Code, which defines when law enforcement officers are permitted to use deadly force. And so the first component of that has to do with reasonable belief. A law enforcement officer may only use deadly force when they have an objectively reasonable belief. Next slide, please. Based on the totality of the circumstances, which the law defines not only in terms of what's happening around the officer, but the officer's conduct as well. Slide, please. And getting into the meat of what necessary is key to, deadly force may be necessary for only one of two permissible reasons. So the first one is, slide, if there's an imminent threat of death or serious bodily injury. And the second, it's a little bit more of a complicated definition. Deadly force may also be deemed necessary under the law to apprehend a fleeing person for either a felony that threatened or resulted in death or serious bodily injury, and where the officer reasonably believes that the person will cause death or serious bodily injury to another person unless they're immediately apprehended, right? So there's sort of a carve out even within that, is that for the fleeing felon justification to be applicable, if feasible, the officer also has to make reasonable efforts to identify themselves as a police officer and issue a warning that the deadly force could be used. Now, there's sort of a carve out to that carve out. The officer doesn't have to do that if they have an objectively reasonable belief that the person already knows that. But otherwise, those identification and warning requirements apply to a fleeing felon situation. Okay, thanks, Marshall. Next slide. There are other key provisions, of course. As was discussed earlier, there's a key provision that states explicitly that an officer's tactical repositioning during an incident is not deemed retreat under the law. And so while an officer need not retreat, the law, of course, suggests that they ought to engage in tactical repositioning where possible. And the law also has a definition of what an imminent threat of death or serious bodily injury is. Again, it's not some amorphous future threat, but it's a quite acute threat as defined in the law here. And again, the totality of the circumstances, among other things, includes the conduct of the officer. And so these are all things that ought to be spelled out crystal clear in Sacramento's use of force policy. But as I think you're already aware, and as some of the discussion this evening has already circled around, there are some glaring omissions in the policy, and I'm going to turn it over to Marshall at this point to walk through some of those.
Thank you, Sean. And even before we delve a little bit deeper into the specifics of the Sacramento Police Department's policy updates, we did want to acknowledge the progress made in the use of force policy just as it was already mentioned earlier by the DOJ, that there were a number of places in the policy that did make great improvements. And I highlighted three of them that were really important that the SPD focused on, which was requiring officers to consider the proportionality when deciding whether to use force. They made improvements on incorporating some of the language from AB 392, and they also instructed officers to use crisis intervention techniques and consider whether people are physically incapable of responding to officer commands when confronted with a person who appears to be experiencing a behavioral health crisis. And there were many other great updates that were made in the policy. I just chose to focus on these three as they appear to be some of the most important ones that were made. And we just want to make sure to acknowledge these updates because progress is being made. There are changes that are happening for the better. But however, as the ACLU, we're still deeply troubled and concerned about other key aspects that are missing from use of force policy. We don't want the acknowledgement of progress to overshadow the importance that there is more work that needs to be done. There are times when acknowledgement of progress is presented, it tends to ignore the simultaneous plea for change. And we do not want this to detract from the critical sense of urgency that these policies need to be updated even more. We are in month 9 of 2020, and this AB 392 law was implemented in January of 2020. We do not want to create the impression that all is well with the SPD's use of force policy, because all is not well. The SPD policies can and must do better, especially for the safety of the officers and the community. And these were mentioned earlier by the DOJ, some key areas that the police department needs to improve in its policies. One area is requiring the officers to use deadly force when necessary. The second is making a clear distinction between retreat versus the de-escalation tactics. And the third is properly including the complete definition of imminent threat. And we touched on these a lot throughout the presentation today thus far, so I'll do my best to not repeat anything too much. But I did want to provide some concrete examples of being able to see exactly where the improvements can be made. So for example, in the middle section from the SPD's policy on page 1, section B3, it does properly mention the perspective that the officer must have, which is reasonable. And you see that in the yellow highlighted section. But the ACLU, just like the DOJ, is recommending that the policy be updated to also include the use of force necessary standard. It is really key to keep those two clear distinctions separated. The perspective, which is reasonable for the officer, and then the necessary standard for deadly force. That is super crucial to making sure we have a clear, consistent policy, because words do matter. Here's a second example on page 4 of SPD's policy, section C5. And the highlighted sections talk about the deadly force where it can be used. And it, again, only mentions the perspective of the reasonable officer, but it fails to include the importance of mentioning necessary for the use of force. And again, we have here the inconsistencies of making a clear distinction between the perspective of reasonable and the standard of necessary for use of force. And here's a third example of where an improvement can be made on SPD's policy. On page 5, section H2, it talks about when they can discharge a firearm. And it only again mentions the perspective, reasonably believes. And the ACLU is recommending that this section needs to be updated to include the necessary standard. As it is written currently, the policy privileges the reasonable standard in a way that conveys that the reasonable standard applies to deadly force as well as non-deadly force, which is not accurate. So these are examples of how the SPD's use of force policy is not that it's incorrect, it's just incomplete. And when we have people dying, we need to make sure as best as possible that there's clear and precise policies being used. And here's a second point, making it clear of the retreat versus de-escalation tactic. Currently, as written in the SPD's use of force policy, they fail to mention the language of, for the purposes of this subdivision, retreat does not mean tactical repositioning or other de-escalation tactics. This is very important because it is clear that the legislator wants us to know that there's a difference between retreating and a difference between de-escalation tactics. And this is important so that there can be the elimination of the legal argument that police officers don't have to retreat, because they don't have to retreat, but they should definitely use de-escalation tactics. And then the last point, the imminent threat definition is not complete. As is currently written, the SPD's use of force policy does not include the important aspect that an imminent harm is not merely a fear of future harm, no matter how great the fear and no matter how great the likelihood of the harm, but is one that from appearances must be instantly confronted and addressed. This section is crucial because imminent threat is an important definition in understanding when deadly force is justified. Because deadly force can be used based on if there is an imminent threat. So we cannot afford to be loose with this definition. It is important to include the whole definition because words matter. And now I'm going to turn it back over to Sean, who's going to discuss some of the city attorney's arguments about SAC PDs being in compliance with AB 392.
Yeah, and I don't want us to get in a sort of a rebuttal stance in terms of the city attorney's earlier presentation publicly to the commission, but I do want to complicate two of the positions that we took from that presentation in a way that will hopefully be useful to the commission. One position that we understood the city attorney to take is that because the word necessary is in the initial first paragraph of the policy, that's enough to sort of cover the rest of the parts of the policy where that word is not used in conjunction with deadly force standards. So I'll say I see a very concrete practical issue with that beyond the fact that I think the language of the law is what it is, and if the language of the policy doesn't track that the policy's not incomplete and likely not compliant. But the practical issue is that as I understand it, this is a policy document that will be used in evaluating internally whether police officers have done what they were supposed to do, including in internal affairs investigations. And it seems that by writing a policy that's unclear in this way, by not including the word necessary, it's inviting situations where in those internal affair investigations, even officers who've clearly used force that was not necessary, that they'll be able to essentially argue that they still complied with the policy as written. And the whole point of these things is for the policy to be as clear as possible so that there are standards as dictated by law here that apply to everyone. And so that seems like a serious problem to us, is that even if there's sort of an implication that necessary that applies throughout the document, it's just not clear enough to actually comply with AB 392, and it's going to result in these practical issues when evaluating incidents after the fact. Another position that we understand the city attorney to be taking is that, Graham v. Connor is still the law of the land, and that therefore some of the references to Graham are appropriate. It's important to understand what Graham v. Connor is and does. It's a constitutional decision. And so all it's doing is setting a bare constitutional minimum for evaluating use of force under the Fourth Amendment. But Graham versus Connor, there's nothing about it, in our opinion, that requires its standards to be built into police policies in any other way, except as a recognition that this is the floor. And you absolutely can't go below the floor, but the sky's the limit above that. And so, again, we respect the role of the city attorney's office. We don't want to get into sort of a rebuttal posture here, but we just think it's important to recognize that some of these issues present there are additional dimensions that are quite important to some of these issues. And Marshall, I think there's one more slide that you're going to handle, and then we'll try to wrap up. Hopefully that was quick enough for everybody.
Yes, thank you, Sean. And this is our last slide. And we just wanted to conclude that upon our review of SPD's use of force policy, we are taking the position that they are not in compliance with AB 392, mainly because of the importance and the omissions of requiring the necessary components throughout and being consistent, not completely using the definition of imminent, and also not making the distinction between retreat and de-escalation tactics. And those are very, very important because words matter. And we as the ACLU are disappointed that the policy as currently written does not incorporate the input provided by the Sacramento community, the Sacramento Police Review Commission, and also the Department of Justice. And we believe that the Sacramento Police Department should immediately update the use of force policy for the protection of not only the officers, but also the community.
Thank you, Sean, and thank you, Marshall. I'll open it up now to commissioners we're going to open it up to public comment. Mandy.
Thank you, Mario. We have one caller on this item. May I have my first caller, please? Welcome to the meeting. You have 2 minutes to address the commission.
Do I start now? They're still talking.
No, you're up.
Oh, I'm on. Okay. First of all, I'd like to get copies of the ACL PowerPoint because it has some very important items. So I would like to find out how I can get copies of that. Also, I had 3 other comments or questions. I'm wanting to know what continued role that the ACLU will play in ensuring that SPD is compliant with SB 392. And will the ACLU have any role in ensuring that the AG recommendations are implemented? And also getting some feedback from the ACLU as to the AG findings that, for example, blacks are stopped more than whites, and yet contraband is found less with blacks than it is for whites, which was statistically clearly racial bias. So I was wanting to know what involvement ACLU will have going forward.
Are those your final comments?
Yes, that's it. I'd like some, yeah, if I can get some answers, I'd appreciate it. Thank you.
Thank you.
If the commission will give us a moment, we could certainly try to briefly address those questions, but it's of course your floor.
Mandy, correct me if I'm, one, we were probably going to ask you similar questions anyway, Sean, but I just want to check in with Mandy that procedurally, I think that there's, are we able to do that? If we are, I'm happy to do that. I just don't want to.
I'll have legal correct me if I'm wrong, but public comments are heard and then we don't typically address them.
Got it. Okay. Well, I think, go ahead.
If there's a technical question that can be addressed, I believe that was the first question about access to the
PowerPoint.
Yes.
Sean, could we get access to your PowerPoint and we'll make it public? We'll post it somewhere.
Yes. We can share a version of that either later this evening or tomorrow, and if it's posted publicly, that'd be great.
Okay.
Sean,
so
if you can email that to me, Mandy, I can attach it to the item.
Marshall's the PowerPoint master, so he'll hopefully be able to take care of that. But
Great. Thank you.
okay, perfect. Then let's move forward to Commissioner comments and questions. Commissioner Alcara.
Yes, I just want to thank the ACLU. I want to thank you two, as well as Adriana, for doing the reports in the past, which served as a foundation for us to really it was a report card. It's pretty much a report card of our police department, and what are the areas that we need to focus on. And it really did make a difference, especially on the commission, as well as the use of force committee for the department. And so I just really want to thank the ACLU and look forward to continue working with all of you as we move forward.
Thank you, Commissioner Alcara. Next, we'll go to Commissioner Savage-Sangwan.
Thanks, and thanks, John and Marshall, for being here yet again on this continued journey with us on this issue. I think I have a question that's actually, I think, in a similar spirit to the public comment, which is just, we are in this position where we've been working on this issue. The commission made recommendations. The state changed the law. You all weighed in. The California Department of Justice weighed in, and yet the city, the police department, the city attorney maintained their position. And so, and to date, the city council has declined to weigh in and to make any changes. And so I guess based on your experience, I imagine you're dealing with this similar issue in other cities across the state. And in your experience, what is the most effective remedy for us at this point?
Marshall, I'll take that briefly, but feel free to chime in. I think, the level of engagement on this issue in Sacramento over the past few years has been impressive. But what's obviously wanting is, seemingly a willingness from the city council and the police department to take these additional steps that seem, I think, frankly, obvious to a lot of people. And it sounds like, I couldn't completely tell from some of the comments earlier, it sounds like there might have already been some progress on some of the issues where, there have been calls to, adjust the language of the policy to bring it into compliance with AB 392. If that's not happening, I would hope that ongoing engagement on this becomes a part of what the public is calling for, as there are requests for policing to be fundamentally reimagined in this day and age. And ultimately, I'll say, there have been moves to hold cities accountable through lawsuits. For example, our colleagues at the ACLU of Southern California have sued the city of Pomona because it's using a broadly defective Lexapol use of force policy instead of adopting AB 392's requirements. That's always a bad option for everybody. But that's something that in some places has needed to happen apparently, where cities have been unwilling to frankly write policies that comply with the law.
Thank you.
Are there any other commissioners with questions? I don't see any raised hands, either through the raise hand feature or visually. So I'm gonna close and just thank our presenters. Thank you, Mr. Riordan. Thank you, Mr. Arnwine. I do want to add my voice and just say thank you. You've consistently come before the commission to give us your perspective on the policy, on the use of force policy. This was before we had AB 392 be state law. And then since then, you've come and shared your perspective on the policy. I also want to thank you for continuing to engage in the various work groups as we take a look at both current recommendations and future recommendations. There have been some consistent partners that we reach out to, and you're one of those. And so we just want to make sure that we thank you for your technical support and that your organization's help and your individual work is greatly appreciated.
Great. Thanks so much for inviting us.
Yes, thank you all for having us.
Thank you.